Okay, so welcome. Today we have the privilege of hearing from Professor Emeritus Colin Bennett from the Department of Political Science at the University of Victoria. Colin is also currently a fellow at the Center for Global Studies, also at the University of Victoria. Colin has produced a remarkable amount of scholarship on privacy governance over the years. He continues to engage in a lot of comparative work across European, Canadian, US jurisdictions, pretty much everywhere, and using his spare time now to consult on a lot of things. He's still very much in the weeds with a lot of developments here. So even though Colin has sort of stepped away from the teaching and other academic service duties, we have him still very much engaged with regulatory reform on a whole range of privacy issues that impact us on an everyday basis. So we get the benefit of hearing from Colin today on the political influence industry in Canada and the impacts on privacy and steps toward regulatory reform. So thank you, Colin.
Okay, thanks, Adam. And delighted to be here. It's my first time at Waterloo, can you believe? Lived in Canada for ages, never been here. So it's delightful to be here at your campus. I'm going to keep this pretty informal, and I don't want to speak for more than half an hour so that we can have plenty of time for Q&A, okay? My most recent work has been about the profiling of personal data in the political space by political parties and other political organizations. And so what I want to do today is give you a bit of a sense of the work that I've been doing. Some introduction about privacy and its importance for democracy, first of all. A lot of the talk will be about the appropriate reconciliation between, on the one hand, the need of our political parties to engage people and to mobilize them to vote and to become part of the political system, but also what I come to call voter surveillance, which is the inappropriate profiling of data on voters, and which, you know, has been in the news a great deal, both in Canada and globally. I want to say something about the impact of artificial intelligence on campaigning. There's been a recent report on that, and this is kind of speculative. But I want to suggest some of the ways that AI will impact our political space. And then the center of the talk is really a bit about this, what we've called the influence industry in Canada. I've been doing a bit of work with Open Media, the NGO in Vancouver, and we've been trying to profile the companies that actually work for our political parties and what they do and how extensive they are. There's a regulatory gap. Political parties are not covered by our privacy laws, at least not nationally at any rate. They are covered by some. And I want to conclude by talking about what some of us have been trying to do about that, with a conclusion concerning a court case that's been going through in BC. So hopefully there's something for everybody, a bit of tech, a bit of politics, a bit of law, a bit of advocacy, and we'll see how we go. And if there isn't, then you can ask questions. Okay. Just a shout out, first of all, for the Office of the Privacy Commissioner of Canada. I want to make the point that the notion of the relationship between the protection of personal data and democracy is now becoming a really, really current set of issues. It was always there. If you look at the literature on privacy, it was always something that was part of the literature. It's important to democratic accountability, but it's now something that the privacy commissioners are very aware of. And this is a joint statement on privacy and democratic rights that was put out by the Canadian Privacy Commissioner, joined by many, many of his colleagues this last December. And then I wrote a report for the Privacy Commissioners of Canada on the privacy and voter surveillance and democratic accountability. It's behind me there, and try to think through the various ways that the protection of personal data and the application of privacy rights affects and can affect our democracy and why it's important for democracy, for different forms of democracy. I don't want to get into this in any detail, but for liberal democracy, reinforcing competition, for participatory democracy, allowing our ability to vote freely, speak out, engage in interest groups, etc., and also to make choices under conditions of genuine reflection. So if you're interested, the Information Commissioner's Office in England, the UK, put out this report a couple of years ago. And the bottom line, the punchline is this, is that we've always known that the protection of data and privacy rights have been important for democracy in the abstract. But until recently, and until the scandals that surrounded the Trump election and the Brexit referendum in the UK, we have known relatively little about how privacy is actually compromised by democracy, how it's compromised by campaigning, how it's compromised by the new technologies and practices that we see entering political campaigns around the world, and by the agents that seek to mobilize and engage, encourage us to vote. So it's very much now part of the regulatory debate in ways that it wasn't before. Another group I'd just like to pay some tribute to is Tactical Tech, the German organization tacticaltech.org, and they've got a larger project on the global political influence industry and have been collecting information from a variety of countries about the companies that are working for political candidates and parties in different countries. And they make a very useful distinction between personal data that's used as a political asset through voter relationship management systems. I want to say a bit more about that. Personal data is political intelligence, where through testing and experimentation, one's political views and one's susceptibility to political influence is tested over and over again online. And personal data is political influence through the process of micro-targeting. The move from mass messaging to a broad community of citizens to more micro-based messages targeted at specific individuals or group of individuals. Now that trend has been happening in Canada as it happens in other countries, meaning, of course, that parties, candidates, organizations need to know more about you in order to know what pushes your buttons and what messages you're likely to respond to. So those are all some sort of global trends and as a way of introduction. So this is a slide that I think is an example of what is a voter relationship management system. 15 years ago or so, the Liberal Party of Canada developed a platform called Liberalist. It was developed in partnership with the company that worked for the Democratic Party in the United States, the Voter Activation Network. And it's a voter identification and relationship management system jointly developed by the Liberal Party and the Voter Activation Network, and with claims that it meets the demands of a 20th century campaign. The critical thing about these platforms is that they are based upon the voters list that political parties legally get from Elections Canada. So in other words, unlike commercial organizations, political parties have a huge advantage in the sense that they have comprehensive and relatively accurate data on individuals and where they live. And it's that provides the backbone, the infrastructure for a platform like this, which allows them to keep track of membership levels, manage local campaigns, strategically contact voters, map out support and opposition across your riding, track key emerging issues, facilitate grassroots campaigns, and develop micro-targeted and demagogic specific messaging. Now, that is incredibly important because once they have that backbone, once they have that basic infrastructure of name and addressing, they can then build upon that with data that comes in from a variety of other sources. information collected on the doorstep, information collected online, information collected through telephones, petitions, polling, and of course, social media. And so over time, these databases have grown dramatically. They've become more sophisticated. They've become more extensive. And this is also mirrored by one from the Conservatives and also one from the NDP. And they are not transparent. That's the point. One's rights to access that data about yourself, one's rights to see it, one's rights to correct it, one's rights to know to whom it is being communicated, the sort of rights you'd have with corporations who would run a database like this do not exist with respect to political parties. And that's a regulatory gap that I and others identified. Sorry.
So on the income tax forms that we fill out, there's
Yeah.
a state, there's a box checking.
Yeah.
Should we check that box for this is for not polling, but for beyond the
Voters list, I do,
Okay.
because I want to vote.
That's
Right.
So we have two options.
That's exactly right. That's exactly the issue. It's a compulsory, it's a pretty compulsory, it's very, very difficult to exclude yourself from that system. So in other words, the parties have that advantage, okay? And whereas you might have rights with Elections Canada in correcting that information because you have an interest in it being accurate, you do not have rights with respect to the political parties of how that's being matched against a whole variety of other information that might be included on there. So that's what we've been trying to change, okay? Political parties have been quite happy to impose privacy rules on businesses, on government agencies, but not on themselves. And that system is also supported by smartphone applications. This is a thing called minivan. The minivan, and so when canvassers come around the door, they will have a smartphone application. I'm not sure that this is the most recent screenshot, but they can put in that information very, very rapidly about who they are, whether you're a supporter, whether you're not a supporter, what issues you might be interested, and that feeds directly in real time back to the Central Liberalist database. The other thing that is occurring in Canada, and I am talking exclusively about Canada here because it's dangerous to generalize it from trends in the United States to what's happening here. We're a different country, is the way that information from membership levels, donors, supporters, etc., then finds its way into Facebook for the purposes of constructing lookalike audiences, okay? So we know this happens. We know that it's a way that political parties that can then reach out to individuals who might have similar views as oneself on the correct assumption that we engage on social media typically with people who do have similar political views as ourselves, right? And so this is also something that is really quite opaque as well. The construction of customized or lookalike audiences, which allows then Facebook, Meta, to determine the kind of people that might also like to see that ad about Justin Trudeau or Pierre Poilievre or on student loan programs or whatever. That's also part of the system. And we know about this because this was exactly the practice that was exposed in BC when our regulator in BC looked at provincial political parties, found this was happening and called it out and said, I don't think people have a reasonable expectation that when they give their email address, for example, for a political party, that it's going to end up in, with Facebook. But that's debatable. And I just want to throw this one here as well. This was an article a couple of years ago in the Hill Times, and there was a perception that the Liberals had got far ahead in their data operations, probably an accurate perception by the Conservatives. The Conservatives were ahead, in the Harper years. And so Poilievre was very, very concerned to do something about this. And so they hired a new voter ID and management set of strategists with Mike Price as the executive director. And I just want to put out this quote here from on predictive modeling. Let's say a voter clicks on one of our Facebook ads 3 times, right? We can send a volunteer to knock on your door armed with a pretty accurate profile of the kind of person you are, what issues are important to you, and individually tailored talking points just for you, okay? So that, therefore, is the reverse process, right? Okay, you clicked on that ad. You're interested in the environment. You're interested in student loans. You're interested in this. Shows up at the door. Hey, do you want to have a conversation about this? Now, I have no evidence that the Conservatives are actually doing that at the moment. I have no evidence that they will do that in the next election. But boy, it's a powerful tool. You know, it really is. Okay, and so it's that kind of thing where there's no transparency. And I think a lot of people would sort of find a bit creepy. You know, wait a minute, how do you know that about me? And that goes to the heart of, you know, privacy rights. So anyway, stay tuned on that one. I want to say something about AI very quickly. This is a new report by Michel Bartleman and Elizabeth Dubois of the University of Ottawa, the political uses of AI in Canada. That was put out this last January. And I think that I'm speculating here that one of the ways that AI is going to influence our campaigning in Canada is because of an easier and quicker aggregation and predictive modeling of polling data, social media data, to identify issues, swing ridings, persuadable voters. So everything that those platforms could do at the moment suddenly gets a lot quicker because of artificial intelligence. Sentiment analysis, opinion mining, the report talks about. The increasing use of synthetic images, videos, and text during and between campaigns. We've also seen a lot of examples of those, not so much in Canada, but synthetics, often called deep fakes. We'll be seeing those in the next election. You can guess what they're likely to look like. They're probably going to be pretty identifiable, but, you know, they're going to be there. This third point, I think is going to be impactful. The increasing speed of campaign communications and responses and counter responses with increased negativity. You know, if a campaign is, you know, now using ChatGPT or one of these other tools to construct the text in order to respond to the prior message that they're getting from the opposition, then things are going to get quicker and more negative. So there'll be an increasing speed of response and counter response through the use of instruments like ChatGPT and other AI tools. You're already seeing that as well. And I think that's going to mean more negativity. There's a reduced cost of ad creation. Ads are still pretty expensive to create, political ads, particularly micro-targeted ads. It's all very well to determine that that particular demographic will be very interested in that particular subject, but you've still got to create the content. You know, if you know, for example, that, you know, elderly male Asian voters in Vancouver are very, very concerned about drug use, well, that's fine, and they are, but you've still got to create the content that's targeted to those people, and that's still expensive. Costs are reduced through AI considerably. Costs of content creation are reduced considerably, allowing more precise micro-targeting in combination with existing voter analytics, and I think probably further information disorder. A lot of people have written about information disorder. So I throw that out. That's a terrific report from Elizabeth Dubois. And then the work that I've been doing with open media, I was hoping the report would be actually public by now, but there's been some delays. But I'll just mention it very, very briefly. And this feeds upon the work that's been done by Tactical Tech, the political influence industry. So what we've looked at is Elections Canada filings to profile the companies that have been employed by Canadian political parties at federal, provincial, and municipal levels. So this is open data and you can see the companies that are receiving money from parties. It's not consistent data, unfortunately. The rules about this vary between provinces and at the federal level. But the influence industry is large. We've identified over 140 different companies that operate beneath the structure of the party political battle. Some of them are obvious to you, but many of them might not be. Many of them are not doing particularly controversial things, right? Many of them might not be processing personal data or personally identifiable data, but some of them are, right, under contract. So we're trying to profile the types of companies that actually get employed. And they come in a variety of different categories. Marketing and advertising, one. That's the, the content creation, the advertising agencies. Data analytics, intelligence, and polling, the analysis of the data from the platforms, figuring out what the trends are, what the issue trends are, what are the persuadable publics, okay? There's an industry there. The voter contact companies, they're the ones that will be phoning you up. They're the ones that will be generating the robocalling messages. Did anybody get that robo-text from Pierre Poilievre a few weeks ago about carbon pricing? You get that one? Oh, was I the only one? Oh, geez, what have I been doing wrong? No, this was a randomly generated text message saying, reply with stop if you want to stop the carbon tax, right? They didn't actually have my number because it's generated through random numbers, but those are the sort of companies that are involved in voter contact. Database management, the actual management of the voter relationship management systems themselves. That's the voter, the social media platforms you're familiar with, but it's not just Meta. It's not just X, Twitter. It's a variety of others as well, including TikTok, where those platforms are then used for the generation of contact. And then, of course, fundraising. And political engagement is increasingly about raising money. It's increasingly about fundraising. The companies involved are varied, large and small, narrow and national, and several fall into multiple categories, so they can't be defined that clearly. Many work exclusively for parties with a shared ideological perspective and will say so. We work for conservative parties. We work for liberal parties. Left-leaning or right-leaning. And there's also clearly a revolving door of personnel between former staffers of political parties and current company personnel. So there's a bit of a snapshot of the report that we're trying to do with open media. It is a snapshot and there's all kinds of gaps, but we're not aware that anybody's really done anything like this before. And as I'm going to explain at the end of the talk, I think this has an enormous regulatory problem, right? Because while many of these companies are in fact regulated by our privacy laws, when the political parties are not, you have a huge regulatory gap there and attention. So moving on and then to conclude really about the regulatory situation. It's complex. And I'm not a lawyer, and if I get too deep into the weeds of the law, my brain starts hurting, as Monty Python used to say. But political parties are covered by neither PIPEDA, the Personal Information Protection Electronic Act, the legislation that covers our private sector at the federal level, nor by the Privacy Act, the rules which govern government agencies. We thought they might be covered by PIPEDA, and we lodged a complaint to the Privacy Commission. The Privacy Commissioner said no. The gist of the complaint was that political parties do engage in an awful lot of activity that looks very commercial, and PIPEDA is based on commercial activity. But the Commissioner said, no, that's not the purpose of political parties. Fair enough. You know, they're for political engagement, they're not commercial, so it doesn't, not covered. They're not covered by provincial privacy laws, such as the one in Ontario, except BC's Personal Information Protection Act and Quebec's new Law 25, which does extend regulation to provincial political parties and candidates. Now, this is important. BC's Personal Information Protection Act does apply to our provincial political parties. We believe it also applies to federal political parties to the extent that they are active in BC and collecting data on BC citizens. Okay? And there's a court case about that as we speak. Right? Same issues might be raised in Quebec. So there's a bit of regulatory intervention there. And a few years, 2019, the BC Commissioner did a report on provincial political parties. And there we get some insights into what the provincial political parties were doing. And you can infer from that that if the provincial parties are doing it, the feds must be doing it as well. But federal political parties were largely exempted from national telemarketing rules and from CASL, the Canada anti-spam legislation. They will say that they will give you an unsubscribe option, most of them, but if you receive some spam from a political parties, you know, they don't have to. The use and disclosure of the list of electors is regulated under the Canada Elections Act. So in other words, if a party or a candidate or a volunteer misuses the data from the Canada, and there's some pretty severe penalties there. Okay, so those rules do apply to the voters list, the names and addresses that come to political parties, but they do not apply to the larger set of data that political parties use to supplement. The CEA also now obliges the federal political parties to develop and submit privacy policies, but those privacy policies are quite weak. Then by no means cover the full range of privacy principles, and so that is also being challenged. And that this is I'm getting a bit short on time, but if you want to look at this was 2018, Bill C-76. That was what the statements that have to be in privacy policies of political parties. There are huge gaps, no standards of necessity relevance. They can basically collect what they want, some vague exemptions, unclear about the application, no clear contact information provided, or that has changed. They tend to be embedded in websites, the prime purpose of which is to capture contact details. So, you know, if you go to the website and you ask a question about the privacy policy, and you send a note to the privacy officer, well, they're capturing your email address, and you don't know what's happening to that. And there's no real oversight or enforcement. So this had created a pressure for reform, strong statements by federal and provincial privacy regulators, recommendations by the Ethics Committee in the House of Commons, steady exposure of the issue in the media, and activism by civil society groups. But this has been going on for 12 years. You know, we first sort of raised consciousness about this, you know, not 12 years ago, and it's been a steady fight ever since. So none of that did any good. And then the Center for Digital Rights, which is the NGO funded by Jim Bosse, in 2018, decided to launch a series of complaints to key regulators across the country about the lack of privacy protection for federal political parties. The Competition Bureau didn't get anywhere. The CRTC, not sure where that is at the moment. Elections Canada. The argument was that the rules in the Elections Act say that the voters list should only be used for the purposes of, quote unquote, communicating with electors. Okay. Now, the complaint then said, well, wait a minute. What do we actually mean by communicating with electors? Number one, we know that a lot of that data is used for other purposes. It's used, for example, for vetting appointments. Are you a donor? That kind of thing. We also know that data is being used. I mean, when these words were written, was it really anticipated that that data would then be used to construct massive databases to profile the entire Canadian electorate? Is that really too communicating with electors? And what do we mean by communicating with electors? Think about that phrase, communicating with electors. Well, going to the doorstep and having a conversation, clearly. And that's what was envisaged. But sending a robotext, sending an ad on your Facebook feed, which is intended to either get you to vote or not to vote, is that engagement? Is that communication? Or is that some form of manipulation? Right? So anyway, we put all these very, very persuasive arguments to the Commissioner of Elections, Canada Commission of Elections, who rejected all of them and said, we don't want to have absolutely nothing to do with this issue. We are not going to regulate here. We're not going to do anything about it. What that meant, however, was that the political parties could not then say, we have our regulator in Elections Canada, because it was quite clear that Elections Canada didn't want to do anything about it. So we went to the Privacy Commission of Canada, and they said, no, PIPEDA does not apply to FPPs. And then to the Office of the Information Commissioner in British Columbia, which does have jurisdiction over provincial political parties. And the complaint was based on access to personal information requests under PIPA. So certain citizens went to the federal political parties and said, please give us the information you have on us. They gave some information, they didn't give everything. They then complained, or the Center for Digital Rights did. And that then created a jurisdictional battle, because the parties then said, we are not subject to provincial law here. We're federal political parties, we're subject to federal law. Well, no, federal political parties are federated structures, and their constituency associations are locally based. And if they're collecting data in BC on me or other BC citizens, they should be regulated by BC law. That's the argument. So the BC commissioner then delegated one of his predecessors to write a report and ruled that FPPs were in fact organizations under BC's Personal Information Protection Act and had to comply. The parties were making constitutional arguments here about paramountcy. Some of you, if there's any lawyers in the room, you'll know more about this than me probably. Paramountcy, no frustration of purpose, no operational conflict. In other words, simply by complying with BC law doesn't in any way frustrate the purposes of the Canada Elections Act. It might not be something that political parties want to do, but constitutionally it doesn't frustrate that. And so it's there's no what's called interjurisdictional immunity. In other words, that the federal government sort of occupied the space here. That's what by legislating they occupy the space. Provinces out of the way. No, BC has done it for BC citizens, and therefore we have some rights, and they cannot be abrogated by the federal government. There's also some charter arguments in this as well as to whether or not, you know, the larger process of voter engagement, voter surveillance, etc., in fact, affects one's democratic rights to vote. Those are not engaged. And all three parties, so this was a ruling by the commissioner in BC, all three parties collectively, it's about the only thing all three parties agree on at the moment. They collectively went to court and sought a judicial review of this ruling, saying, no, we are not subject to BC's law. We are fundamentally opposed to this. Enormous amounts of money being spent. This was held in the BC Superior Court this last week. I was there. It was a hearing. There was the judge. There was about 18 lawyers. representing the political parties, the Centre for Digital Rights, Attorney Generals, and one audience member, me. It was this really strange kind of atmosphere for a judge up there. Anyway, what will the judge do? I don't know what it's going to do, but that's where it is at the moment, right? And I can't really say much more than that. And so in the meantime, what the parties did was they passed a little provision in the Budget Implementation Act of 2023 and said, oh, we are now occupying the field. And so buried in the budget was this, and I'll just read you number 3 here, and that's all it says, okay? Section 385(2). The purpose of this section is to provide for a national, uniform, exclusive and complete regime applicable to registered parties and eligible parties respecting the collection, use, disclosure, retention, and disposal of personal information. Right? That's it. 3 provisions, you know, you know, they've got to have a code. And the purpose of that was to send a message to the BC judge saying, butt out, frankly. Well, that's the question, and that's the constitutional question, I understand. Can the federal government do that? Can the federal government say, we occupy the field. This is up to us, even though we're not doing it much, right? So anyway, for those of you who are interested in our constitution, now I'm going to wrap up. And so anyway, there's been quite a lot of reports about this. The government's newly proposed privacy policy won't change how federal public will use voter data. Experts, I'm one of those experts, increasing the number of experts. So that was in April of this year. So they're trying to self-regulate essentially. And so a few conclusions on this issue. The debate is at a critical juncture. I mean, it really is a fight. And it's a fight about privacy on the one hand, the privacy rights of individual Canadians, and the legitimate needs of political parties to engage the electorate. And the fundamental theoretical question here, and a policy question, is how much personal information do parties and candidates actually need about individuals in order to engage them, right? They say, well, the more they know about you, the better they can engage with you. The more they know that you're interested in that subject, the better they can converse with you. Well, maybe that's true. But how much? And shouldn't that information be coming with your consent and transparently? This case could go all the way to the Supreme Court, I'm told. I don't know whether it will. There might be a settlement. There might be some larger political solution. Who knows? But there's implications here for the larger campaign ecosystem. And that's one of the things I think our research is going to identify pretty clearly. Those companies that work for political parties have to comply with Canada's privacy laws to the extent that they're processing personally identifiable information. One of the things that is said in those laws is that you have to do due diligence if you're processing personal data, that those data is collected with personal consent. Okay, we know that because the Privacy Commissioners did an investigation of a company called Aggregate IQ, which was one of the companies embroiled in the Cambridge Analytica fiasco, and they said just that. The company that's doing this work has to make sure that, you know, if it's processing data and making money out of that data, then it has to make sure that it is processing that data and that the source organization has received the appropriate consent or at least statutory authorization to gather it. But that's not the case at the moment with respect to political parties. So I think that there's a massive sort of confusion that's arising here, which is going to have a huge impact, I think. And so, you know, what I'm pleading, one of the problems in this area is that those people who do this work and those people who have been in their bunker and they've not been engaged, they've not been part of the debate, they've just said, no, we're different, we're resisting this, we're not commercial organizations, and we resist the ability, we resist privacy regulation over our rules. We think it would constrain our ability to engage with Canadians. It would have a harmful effect on democracy. And that's it, go away. But I think things are changing there. And so I would be most gratified if there was a larger debate in Canada with all the political parties, and some process whereby one could, get some resolution here so that basic privacy principles, do apply to their operations in a way that it does allow them to operate. But at the moment, they're exceedingly secretive. They're secretive to the Canadian people. They're also secretive to each other. They don't want to reveal what they're doing because of the opposition's, fear of that. And that's where the debate is at the moment. So with that, Adam, I think I will leave it, and hopefully there's plenty of time for Q&A. Thanks a lot for your attention. I said half an hour and it was 40 minutes, so whatever.
Excellent. Thank you, Colin. Okay, so questions from audience members for Colin?
Thanks for your talk, Colin. I was curious as to how many of those 140 influencer companies are domestic and how many are multinational or in other countries?
Yeah, we don't know that. We haven't got complete data on that. The vast majority are domestic. Except of course the social media platforms, if you include that in the categories, right? But many of them are domestically located, but may also be, owned elsewhere or part of a wider. And some of them also operate internationally. There's a company, for example, in Montreal called Data Sciences that operates in other countries in Europe and does work there. So that distinction between domestic and international is increasingly difficult to determine in, current circumstances, I think. But we do find that many of them are domestically related. Some are provincially, we're also looking at municipalities, and one of the things there is that, the more a company can know the locality, the more useful they are in that respect, and tend to have long-term relationships and understandings of particular communities.
And so is this regulatory gap that you identified in Canada, is it unique to Canada? And how does this sort of lack privacy in regards to the voter list and things like that? How is it different in, let's say,
well, to be clear, the voters list itself, which is just name and address and voter number, that is subject to privacy rules in the Elections Act. Right? It's the other stuff that political parties collect that is not, yeah. So in terms of the international comparisons, Canada's not unique. The US, it's a free-for-all, pretty much, because of the First Amendment. Parties have been exempted in Australia. But in most other jurisdictions, political parties are covered and have been covered for a very long time by data protection statutes. So in Europe, the General Data Protection Regulation applies to political parties. Sorry. Oh, it's the Conservative Party, sorry. Not. So where was it? So they're covered in Europe, they're covered in the UK, they're covered in New Zealand, right? And and therefore they're regulated by the commissioners in those countries, and by the Information Commissioner in the UK, by the Commission Nationale in France, other privacy commissioners. And there's no evidence that they can't engage with the electorates, In fact, voting turnout, if that's a measure of engagement, tends to be a lot higher in those countries than it is in North America, So you sometimes get this argument that, if you apply strict privacy rules that, it's going to affect our ability to mobilize the electorate. I don't buy that for a moment, you know. But if you look at it, you have to look at it culturally as well. You can't just look at data protection law. A lot of the rules in Asia, for example, come in elections acts. In Japan, for example, there's extremely strict rules about campaigning in Japan. So to answer your question directly, Canada is a bit of an exception here, yeah. There's no reason for that to continue. Yeah.
This is an interesting question here also where they're getting the data. I mean, there's if they go out there with, you know, an ad and collect it directly from the consumer, that gets. So I just came out of Scotland of GDPR, something I'm a little bit more familiar with.
Yeah.
And if they're collecting it directly and being given directly to somebody working with this, you might argue that there's some consent there. But then you look at all the huge data aggregators out there, and I wonder what percentage is given and which percentage is co-bought.
We don't know. We don't know. We know that they have purchased data. They say they don't do that anymore. They're not, you know, our political parties are not that, they're not rich, you know. They have enormous financial challenges. We know that some of it is scraped, you know, from social media. And then the question comes whether or not that's publicly available data, which is fair game. And we know the debate about that, right? The party will say, well, it's out there, you know, if you put your profile on LinkedIn, then, you know, that's all fair game. I'm not sure. There's a lot of arguments against that. We know from the BC report that they were using data from social media sites, Twitter at the time, LinkedIn, etc. So there's that. The census tract data is used. That tends not to be personal data, but it might very well be personally identifiable data, you know. There's that. There's data from petitions. You know, people don't realize that when you sign a petition, that's, you know, relatively public data, and that can end up, that's very valuable data, petition data. So the honest answer is that we really do not have a complete and accurate picture of the kind of data that ends up in these systems. And I think that's a problem. And, you know, and if the parties have really got something, you know, anything that they think they're doing incorrectly, or anything if they sincerely believe that what they're doing is fine and is all for the purposes of mobilizing the electorate, then why couldn't they let a regulator in there and, you know, do a report and have some more transparency? That's my argument. Yeah.
Or what law decides which of these companies, like who gives the final okay as to which of these final companies they go together?
He's going to.
Because I think could the current government influence the type of companies that they get rid of to possibly get for the future?
Well, in terms of, yeah, well, the political parties do that at any rate, yes, because they have a trusted set of companies that work for them. But you know, they are subject to our privacy rules, and unless there are exemptions, they have to make sure that they get information with people's consent. But the current rules might be that, you know, you might have consented without knowing that you have consented. It's not express consent, it's applied consent. You failed to check that box when you subscribed to that magazine several years ago, you know, and you failed to check that box, and therefore that data becomes part of the larger marketing ecosystem, and it might be picked up by data aggregators, the profiling industry, and used in a variety of ways. Now, this is an active debate in Canada at the moment as we debate the reforms to PIPEDA C27, because and whether or not implied consent still has a role in our system. And my view is it doesn't. what the GDPR says is that if you're going to use consent, you have to make sure it's express consent, right? That it's clear, it's unambiguous, and so on. But if you're in circumstances where you cannot practically get consent from the individual, then you can assert a so-called legitimate interest in that data for the particular purpose that you want to fulfill. That too is in C27, that's in the GDPR. So if the political parties wanted to make a case, as they do in Europe, that, well, they really can't get consent for that data, it's impractical, and there may be circumstances, then they can assert a legitimate interest of needing that data in order to fulfill their legitimate obligations to engage the electorate and mobilize the electorate. And so long as that is transparent, and as long as it is put out there in their privacy policies, as it is in the UK, for example, then we know about it. And then the regulator can come in and say, well, you know, we've had a complaint about that. I want to investigate. I want to do something about it. So that's, in my view, the way that this should work, right? And if you're interested in looking further at this, I was looking a few days ago at the privacy policy of the UK Labour Party, because I was sort of following what's going on in Britain. And it's a very impressive and comprehensive document about the types of personal data that the Labour Party collects, their legal justification for collecting it, who they transfer it to, how it's kept secure, and all of those things. And there you have a far more complete picture about what they're doing with your data, but not in Canada, and not if, not unless we have some kind of accountability to an independent regulator. Yeah. Sorry, could you speak up?
But say that the case escalates and they have to make regulations. Isn't there a conflict of interest?
Well, this is, this a lot of people make a point about this, that they're in a conflict of interest. And, but of course, it's not the political parties that make laws, it's our members of parliament, right? And they're somewhat different from the people who work for political parties. One of the interesting things I found in this area is when I talk to MPs, or I give testimony occasionally through the committees, how ignorant some of our elected representatives are about what's going on behind the scenes in their own. They don't want to know. Just tell me what to say and who to communicate with, And I say, well, I say, oh yeah, that's really interesting what's going on. And of course, they all want to know what the other side's doing as well. But yeah, some people would say there is a conflict of interest here, and it's been pointed out by a lot of people. But the arguments, the rational arguments for why this reform should occur, have fallen on deaf ears, and that's why, that's why we started litigating. I say we. I'm part of that Centre for Digital Rights, and I'm assisting there. But that's why litigation was the only answer, and supported by some resources through CDR and Bill Silly. And all of that's been in public, all of that's been in the newspapers. So it's an interesting way that this has progressed, and we'll see where it goes. Yes, sir.
I might be ignorant of the political process. I have a question concerning, can the notwithstanding clause be used by a political party to justify electronic privacy?
Boy, that actually is an extremely good question. I mean, well, yeah, I mean, given what Mr. Poilievre was saying about this the other day, I don't know. I mean, this whole case in BC is now embroiled in some very, very weighty constitutional arguments. There's a lot of constitutional lawyers who are paying very, very close attention to this. It's gone beyond, the issues concerning campaigning to some larger questions about provincial rights, and the balance in the federation. The notwithstanding clause, in my judgment or my understanding, is something that's actually used by the provinces, by provincial governments, right, to say, no, we do not want to comply with that particular aspect of the charter for various reasons. Now, that then raises the issue about the extent to which all of this is part of larger set of charter rights. This actually is the opposite. This is a provincial government and a provincial regulator saying, we occupy this territory, and the federal government saying, no, you don't, or at least, yeah. And so, yeah, I'd have to get some legal advice on that one.
So I'll make more, I guess, a comment. This really reminds me of AT&T's annoying customer column. So I don't, way back when they were like, oh, no problem, privacy, transparency, we can release what we have on our customers.
Yeah.
And then someone raised their hand and said, well, what about the annoying customer column? We have in our database this column entitled, is this customer really annoying? And maybe we don't want to release this. Because you sit there and you step back and go, okay, what's the harm here? Like there's harm in some directions, right? What's the harm to the population? Because we're talking a lot about rights, but at least in the US, a lot of this actually comes down to harms, which is one of the reasons it never makes any more in the US. And then there's also the harms of the release. So
Yeah.
what are they concerned the harm would be to the release? And I can see competition because they all don't want to know what each other are doing. But then you also ask, is this a harm that's closer to the annoying customer column? Do we have columns entitled, this person looks very manipulatable, general population might react very badly to? Or is it just the sheer amount of data that they think that we will react badly?
Yeah.
Sorry.
Well, just a word about telemarketing. The telemarketing rules that are administered by the CRTC for companies, most of them do not apply to political parties. Most of them, but not all of them. So, for example, political parties are not obliged to use the do not call list. They're supposed to have their own internal do not call list. So if you say, I don't want to be contacted, they're supposed to keep a list of that. That too is something that no regulator has any real control over. And the parties come back and say, yeah, but we can take a number off our list, but there might be people of different political persuasions who are living at that same address. And so do you really want to do that? Okay, so there's a debate there. The larger harm, I don't know, I've written that I think that democracies are as we know, under threat, are declining. The numbers of people in the world who live in democracies is reducing. And that there's been a long-term increase in distrust or lack of trust in democracy and in political leaders. To the extent, therefore, that individuals feel that their political views are being manipulated by practices such as this, and to the extent that they see that coming through annoying calls or annoying texts, I think it probably just adds to the feeling of disillusionment, adds to the feeling of lack of engagement. And I don't know of any data explicitly on this, but I think produces, I think increases what political scientists call the de-alignment, the lack of ability or willingness to engage with political parties, to volunteer for political parties, and in some cases to vote. I'm willing to make that argument. I don't know of any polling on that, but I think that's probably one of the bigger, larger harm which is different, of course, from the annoying customer call from a direct marketer, because there you're just talking about selling insurance. Here, we're talking about democracy. Here, we're talking about communicating about really, really important issues, So, I mean, that's the only answer I'd have to that. It's a great question. But I mean, there's also, I've written about I think there are other harms involved. Micro-targeting produces, an accentuation of this phenomenon called the filter bubble or the echo chamber, the reduction of the national conversation about issues, the ability of parties to say one thing in one place and another thing in another place, to contradict themselves, the lack of engagement, on really serious issues. I think that's pretty much accepted. I think it also has an effect on the nature of the party system. These practices are expensive. Is it only big, rich parties that can afford to do this data analytics? Yes. Although AI might affect that, AI is, can reduce costs. So there are a range of possible answers to the question about the larger harm, right? But the application of privacy law is not the solution, but it's one part of the solution. And it's one part of the solution, I think, in combating the larger problem of misinformation and disinformation, because if you can apply consent rules to the process of micro-targeting, then you go some way to, I think, reducing the worst effects of, those practices. There's a lot there. There's a lot of problems.
Okay, any other questions? I think that last question actually ties things together nicely in terms of your earlier slides, Colin. So about the risks to the democratic process. So everybody, please join me in thanking Colin for your insightful work today. Thank you.
Thank you.